and the equal technical support of the staff of the registry. The first time I sensed the need for virtual courts was in the mid-1990s when I was a practicing lawyer. There was this client of mine. He was ordinarily residing in the United States of America, USA. He had some estranged relationship with his wife, and he approached me for filing a divorce petition. I had advised him to first explore the possibilities of resolving the dispute amicably. And he took my advice, and some terms were offered, which according to my client wasn't reasonable. So he advised me to file a divorce petition. Accordingly, it came to be filed. I told him that the procedure is his presence may be required for each and every hearing in the family courts, for which he agreed. Then it so happened that the case was filed. It went on for about 2 years, and every month we had a hearing. And he was a law-abiding citizen, and he didn't miss even a single hearing. He came all the way from the United States and was attending the proceedings. This was a stage when there was no facility of video conferencing or the facility to represent him by a power agent. Those options were not available at that point of time. So after about 2 years, he said I would opt for this settlement. The reason why he said so was the stage of the case was still for filing of counter by the wife. Though we had so many hearings, we were still in the beginning stage. At that point of time, he asked me what could possibly be the time for completion of the proceedings. And I told him that the way things are going on, and though we have made earnest efforts explaining to the court that we have difficulty in coming, somehow the case could not proceed much. Therefore, it might take a couple of years, which I will not be surprised. This is what I told him. It was at this point of time that he took the offer, which according to him was unreasonable. I then realized that if the facility of a video conferencing was available, most of the hearings could have been completed through video conferencing, where his personal presence was not required. As a matter of fact, he was little disappointed on the way he has used to travel here, and most of the hearings the wife was not there, or the judge was on leave, or both were present but the case could not be taken up, and the judge was a little lenient in giving her time for filing of counter. So all these reasons he took the decision to settle the issue. The point I'm trying to drive is, if there had been a facility of video conferencing at that point of time, probably he would not have gone for this unreasonable settlement and would have seen to it that the case comes to a logical end by itself. From the judiciary's point of view, the need for video conferencing was sensed even about 15 years back, when one of our former Chief Justice of India, Justice R.C. Lahoti, while addressing a conference of the Chief Justices and the Chief Ministers, said that the facilities for e-filing and hearing through video conferences requires to be introduced. He said this in the year 2004. And in his words, I quote, "Records of the court have to be computerized. Facilities for e-filing and hearing through video conferencing need to be introduced. This will eliminate such deficiencies in the working of the courts as are the outcome of human weaknesses. The system will be fast, neat, and clean and accessible with more ease. It would add to the efficiency of the judges. The Supreme Court has to be interlinked with the high courts and the high courts with the subordinate courts, including those situated in the remotest corners of the states. Now, most of the views expressed by our former Chief Justice have been implemented now, like the video conferencing has been introduced. The Supreme Court is interconnected with the high courts and the high courts are connected with the subordinate courts. Likewise, another former Supreme Court judge, Justice S.B. Sinha, in one of his speeches delivered in the same year, that is in 2004, said, video conferencing has been talked about for quite some time, but it is not being implemented, which is a little surprising because it is one way of reducing costs, particularly in matters pertaining to under trials. The amount of time and energy that is expended in bringing under trials to court is quite phenomenal. If a video conferencing facility is established, the costs can be recovered at an earlier date. Now, this again, the views of Justice Sinha has been predominantly met in the sense the under trial prisoners are being dealt with through video conferencing in most of the parts of our state at least. Till the year 2004, the Madras High Court and the District Judiciary did not officially have facilities of hearing cases through video conferencing. Our first hiccup was when the Madurai bench of the Madras High Court was established in the year 2004. And when the judges were required to shuffle and preside intermittently between these two benches, the litigants and the lawyers were caught in between. When some of the cases like a review petition, which requires to be continued to be heard by the same judge who had heard the case earlier, and such judge was not available since he was presiding over the other bench, this situation arose. It is said that necessity is the mother of invention. It is at this point of time that hearing of the case through video conferencing was felt as the only solution. Accordingly, studio-based virtual courts came to be established, and the judges started to interact and proceed with the cases. Initially, there were some challenges which came to be considerably resolved, and today, as all of you are aware of, we are able to handle such a situation with significant ease. This transitional period from the initial difficulties in handling a virtual court till its solution has paved way to successful continuation of cases between the principal bench and the Madurai bench through virtual courts. Similar to this situation, when there was no concrete agenda on the sleeve to extend virtual courts to all types of cases, at least till the month of February of this year, the COVID virus pandemic took all of us by surprise, and when it was realized that the lockdown announced by the government could continue for a while, the Supreme Court felt that the cases throughout the country need not wait till the lockdown is lifted, but could be continued through virtual courts. So within a very short time, I must say, e-filing portal came to be developed by the E-Committee of the Supreme Court, and the rest of the courts followed suit. As we are all now aware of, cases are now being conducted through virtual courts wherever there is a possibility. However, there are a few challenges to in effectively conducting cases through video conferencing. But according to me, in this given situation, these challenges are explicable. But before I endeavor to address the challenges of a virtual court, let us have a brief idea about what a virtual court really is. I would say it is a media through which all the stakeholders in a given case, including the judge and the lawyer, conduct the case through video conferencing mode without physically meeting each other. It is not a place, but rather could be referred to as a facilitator or a service. It does not restrict itself to few court halls, but opens up to hundreds and thousands of court halls. The filing procedure becomes less cumbersome. The proceedings becomes speedy and effective. It would actually open the gateway to the law students and the law apprentices to visit any court or any court proceeding, which facility I think it's restricted for the present for various reasons. Insofar as the viewers are concerned, it does not restrict the number of viewers of the proceedings, but there is a possibility of millions watching it live. There is a possibility of having a live streaming of the cases for public viewing. And in that course, there is absolute transparency of the proceedings. Talking about transparency, the Supreme Court, in a judgment 2018, was dealing with live streaming of important cases of the Supreme Court. And while dealing with that case, the many observations were made in that decision. I'll just read a few lines alone of the decision, which may be relevant for the present topic. According to the Supreme Court, live streaming of court proceedings is feasible due to the advent of technology, and in fact has been adopted in other jurisdictions across the world. Technology is evolving with increasing swiftness, whereas the law and the courts are evolving at a much more measured pace. It can epitomize transparency, good governance, and accountability, and more importantly, open the vista of the courtrooms, transcending the four walls of the rooms to accommodate a large number of viewers to witness the live court proceedings. Introducing and integrating such technology into the courtrooms would give the public a virtual presence in the courtroom and also educate them the working of the court. So there seem to be a substantial advantages in having cases heard through video conferencing. But what could it be its drawbacks? The first thing that comes to my mind is that as a judge, I do not have the full satisfaction of having heard the matter as I would have had in an open regular court. Same could be the case from the point of view of a lawyer who may not derive the gratification of having presented the case in full. For instance, some lawyers in the open regular court, they not only present their case with facts and law, but they add a little, I wouldn't call it gimmicks, I would say little garnishing of the presentation through their voice modulations, body languages, gestures, and facial mannerisms. Now, all these may enhance the effectiveness of presentation. But all these, when heard and viewed in a video presentation, may not be as effective as an open court hearing. There could be other drawbacks, like the cost involved in coping up with the technology. It may be of little burden to some lawyers. They may have to set up their own studio sort of with 2 or 3 screens before them, invest on the necessary supporting electronic devices and related expenditures. I can think of some other drawbacks also. But the question is, can't we overcome these challenges? The answer is definitely yes. But what I could see as a real apprehension, which might be running in the minds of some lawyers, is whether the virtual courts would restrict his or her practice, since it opens an avenue for his counterpart who feeds him the brief to conduct the case from a remote location. Now, this could be an apprehension, but I, I have to tell you, without fear of contradiction, that such an apprehension would only be an illusion or a paradox. As a matter of fact, it would open a floodgate for more number of briefs coming in for such lawyers, for what applies to their counterpart will also apply to them. Now, let's try to understand this issue, this apprehension, through analogies of similar situations. As I had already mentioned, the virtual courts, it is not a place, but a facilitator or a service. Take, for instance, when big-time aggregators venture to online marketing of various services, the small-time players were worried that their business may be affected. Similar to the situation as to when the virtual courts are considerably made operational, the common lawyers or the not so busy lawyers may have some apprehension. But it turned out that when those big time aggregators entered the online marketing, the small players actually stood to benefit substantially. Their initial apprehension was, take for instance, when the aggregators in the cab industry facilitated the general public to book a cab or an auto rickshaw online. The small time cab drivers or auto drivers felt that they may lose their passengers. But when these aggregators like this, Ola or Uber, or there are many of them, when they pull them into their online business, the volume of business of these small time drivers started increasing. I shall give you two more examples. Let's take the case of online booking of food. We have many of them, like Swiggy or Zomato. Now, when they came into the markets, the small restaurant owners, they had their own apprehensions. Their apprehensions, when you see, looks acceptable. What they felt is that their customers would prefer to sit at home and order their best food instead of coming to my restaurant, and therefore these people might block my business. But effectively what happened is the turnover of these small businesses started increasing when these aggregators started to place orders, because their market, online market, was huge. It opened every nook and corner of the area which this restaurant could reach, and therefore their business started increasing. Similar is the case of the online booking of hotels. We all know about this OYO. When they came into the market, offering to have hotels booked online, the small hotels were apprehensive, thinking that it's an easier way for them to book, for the customers to book hotel rooms, and therefore they may not have business. But it so happened that these aggregators entered into some terms with the small hotels, and their businesses, which was the occupancy, which could have been around 10% to 20% in a year, started boosting up, and they all landed up with 70%, 80% market. of occupancy, and that business grew. It is a question of volume. Earlier, all these small-time players were working in a very small market. When the doors opened, the market was huge. There are many other examples, but all these three examples which I gave you, these three analogies, indicate that the advent of online courts or virtual courts could only increase the volume of work of a lawyer who would be able to reach virtually to any court in the country. And this he will be doing while sitting in the comfort of his own office or a home. Therefore, if any lawyer has any of these apprehensions, I would feel that they should try to reconsider their anxiety. Ms. Anand, the host of today's web meeting, made a request that today's topic should be general and not on law. I just thought it would be relevant to refer to the course where the law has already started to seek the assistance of virtual courts for redressal of the grievances, and nothing more on law. We'll just have a quick look at what happened, how the law started progressing towards these virtual courts. In the year 2009, the Code of Criminal Procedure came to be amended, whereby the police officers were permitted to record statement of witnesses under section 161 CRPC by audio, video, electronic device. The magistrates were also empowered to record confessions and statements under section 164 through these audio video devices. Likewise, the term evidence, the definition of the term evidence under the Evidence Act brought electronic records also under the purview of its definition. That was made through an amendment in the year 2000. The Supreme Court had also permitted recording of evidence in a criminal trial, though video conferencing depending on the facts of the case. And there are a couple of judgments also to this effect, where the Supreme Court had permitted recording of evidence through video conferencing. Likewise, in another decision, the recording of evidence of the witnesses through video conferencing in the presence of the accused was also recognized to have met the mandate of section 273 of the Criminal Procedure Code in the presence of the accused. In another case, in the year 2019, the Supreme Court also directed formation of one-stop centers with video conferencing facilities for child victims dealt under the POCSO Act. Likewise, while dealing with the contagion of COVID-19 virus, the child welfare committees, the juvenile justice boards, and the other children courts were mandated to adhere to video conferencing for monitoring and other purposes. That is the latest judgment which you all would be aware of. But these are not exhaustive. There are only a few instances to show that the law has already resorted to recognize video conferencing as a mechanism for a justice delivery system. Before I conclude, if any of you are wondering whether this judge is trying to indicate that all the courts in the court buildings have to be closed and cases should be conducted through video conferencing, the answer is definitely no. Let me make it clear that all the cases cannot be conducted through video conferencing. There could be some. Likewise, all the stages of a case cannot be conducted through video conferencing. There could be some stages where video conferencing may come of some help. What I have tried to convey is that there are some cases which can be disposed of through video conferencing, and wherever it is required that the case should be heard in an open court, it has to be. when such cases or the stages of cases are determined or it is identified, we should bear in mind that the advantage of hearing the case through a virtual court is much more than the challenges it poses, and therefore try and overcome the challenges to reap its benefits. Thank you very much. And if there's an interactive session, I'm open for it.
Thank you, Lordship. Are you able to hear us? That's the challenge. Your Lordship is able to hear us?
Madhuri, I can see you're speaking, but I can't.
Can't hear us. Is the speaker on? I mean, but how will we answer here? Thank you very much. Participants, Lordship will be answering to me through the phone, and probably we can see if we'll be able to do that. Try to understand, you know, one of the challenges we are facing now. You can't hear me. Can you hear me through the phone? I think he's. One of the challenges we are facing now is the. No, he's not able to hear.
Now I can hear.
Oh, you're able to hear now? Okay, great.
No,
See, I think one of the challenges that we are facing now is also the connectivity issues that we are there.
Yeah, anyway. Now I can hear you.
Oh, great, fantastic. So, okay. Okay, participants, if you have...
ask anything. Was my entire audio clear when I...
Yes, it was entirely clear and we were able to hear you all perfectly fine. Except that you were not able to hear us. We were able to hear you.
Okay.
Friends, if you have any questions, please raise hands and we can ask him the questions. Please do not ask questions like when will the High Court open and all those kind of things, because I think it won't be justified for us to ask, because we'll have to wait for the outcome of how things are, because it is all futile. Why people raise hands, my lord? I have a question to your lordship.
Yes.
Now, your lordship was very, very positive in saying that yes, virtual courts have come to stay and we all have to get abreast. And it was a very positive message to say that, you know, even like people who are not, you know, in the high courts or in the cities to appear in the high court, they can appear in the high courts through a different, wherever they are in. Now, considering the situation right now we are in, even afterwards when the courts reopen, would generally be judges be inclined to look at judgments online itself instead of giving a typeset or a paper set? Or do you think it's only a convenience of each and every person who wants to do that?
No, right now what is happening is a stopgap arrangement. We are not the regular. We are also waiting for the regular courts to open, and there are so many ifs and buts to it. As on date, what I know is that we are close till. That is, the system will continue till the 31st of May. Probably, I'm not sure, we may take a decision on this as to what is the mode of hearing after the 31st of May. And that we'll have to wait and watch.
Okay.
I'm also equally placed like you. And
yeah, that's what I've told them, not to ask question on, you know, when the high courts will open. There is a chat window and one of them has asked a question, your view on media trials on e-courts. Says, I'm assuming that, yeah, yes.
Can you repeat the question, please?
Media trial on e-courts.
Insofar as the trials are concerned, there might be some difficulty to have this trial through a virtual court. There are many reasons why a full-fledged trial may not be possible. But then I had quoted another decision where even in the criminal trial, the Supreme Court said you can conduct the trial through video conferencing. But it put a rider to it saying that such a trial would be based on the facts and circumstances of that particular case. In my view, a trial, if conducted in the open court, would be a better trial than a trial in a virtual court.
Okay, thank you. Mr. Ayyappan, Mr. Meyyappan has raised his hands.
Yes.
I'll just unmute him. Mr. Meyyappan?
Honorable Justice and learned friends.
Yes.
Good evening. Milord, thank you for the wonderful session. Barring the technical glitches, the bar is indebted to your Lordship's reception and the overall atmosphere and aura in your Lordship's courtroom, Milord. And having said that, the essence of this open court, if it can be carried over to these virtual courts, that will be great and wonderful. And we need to balance between, the national security and natural justice. And as much as these underprivileged people would be having better access, we should also be careful enough that it should not become for the privileged few who have better connectivity and better connections. And having said that, you have answered most of my doubts, and my anxiety and my apprehensions have been answered. Thank you so much. Thank you.
Thank you, Mr. Mayappan, on that. There is one message in the questionnaire. Would availability of the recording of e-courts in public platforms be infringing the privacy of the litigants? I'll read it again. Would availability of the recording of e-courts in public platforms be infringing the privacy of the litigants? I think Rachi was more referring to conducting cases on, live rather than publishing the recording.
See, right now we are speaking of a baby which is in the womb. We don't know as to how this baby is going to be after it's born, because we are the persons who need to groom the baby in such a way that it transforms itself into a wonderful human being. And I would think it is a little premature to go into all these questions, because this has not been either thought of or contemplated in the near future. And out of probably compulsion and necessity that we have taken up this code. The idea behind today's topic was that in case, and I'm hoping it should not happen, in case we come across another situation where there is a lockdown due to a natural calamity or otherwise, I think we will be now well prepared to meet the situation. Some of the infrastructures have been developed by almost all the courts throughout the country, since everyone is conducting the cases through video conferencing. So we need to wait on the security issues, all this. There are so many technicalities also involved in this. And therefore, we need to just wait till a concrete decision is taken.
Sure, thank you. There's a question which says that they're asking if whether an administrative order is required or a legislation for constitution of the virtual court.
I wouldn't see an administrative order. Probably there could be some amendments also to be introduced for the purpose of establishment of the virtual courts. It's a very big question. There needs to be major amendments to be brought in for establishments of these.
Okay.
Right now, what is happening is it's only a stop arrangement as they earlier.
Correct. One question is that will examination of witnesses made through virtual courts be possible?
I think somebody else has asked that question. The Supreme Court trial, yes, in some cases they are permitted, stating that it depends on the facts or circumstances of the case. It is possible, but whether it's feasible or not has to be decided by that particular court.
I think that's about it in the chat box. That is, I can see here, Lordship, for the questions itself.
Okay. So unless anybody else has got anything to say.
Nobody has raised their hands. I think that's what it is. So I'd like to thank you, Lordship, and thank all the participants for coming out on a Saturday evening, because okay, it doesn't matter anymore whether it's Friday or a weekday or a weekend, because we are all sorry, there's one question that just popped up. Is there a chance for hacking, auditory issue, visibility issue, and unretrieved data is needed? So I don't understand the question.
I was able to get what the viewer was saying. See, the initial itself, I told I'm not a technical person. This hacking has got a lot of technical aspects to it. In fact, when I was preparing the points for today's topic, I came across various inputs on this hacking and all. But I think I will not be the right person to answer that. A person with technical know-how, knowledge should be answering.
That's fine. So I would not want to hold on your lordship anymore on this Saturday evening, and also the participants, because thankfully the technical glitches the challenges which we faced, actually we were able to overcome. So I thank the lordship for actually patiently trying again and again, putting up with us despite the difficulties. And I thank all the participants for actually logging in and hearing us. Wish you all a great weekend. Stay safe, and we hope we'll connect soon when the courts reopen again. Thank you all very much. Thank you.
Thank you very much, Mr. Anand and Ms. Madhuri, and all the persons who have joined this meeting. It was nice speaking with all of you. I wish that you all stay safe till we meet in the courts. Thank you very much.
Thank you. Thank you. Thank you very much.